Go ahead. My name is Tom Jackson. I'm an attorney here in Bismarck, North Dakota. I'm also the Mandan Municipal Judge. I'm 20 plus years in Mandan, so I'll try to limit my jokes at the expense of Bismarck as I go through with this, but otherwise go Braves. So I'm going to start today by, I couldn't get my Zoom necessarily, or my Teams to work here right away, so I missed a portion of Jamie's presentation, and I try to tie it in to what was being said. I know you all, the primary concern is TFFR and how that plays into estate planning, and I will try to do that as best I can, but I'm going to start about talking about probate just broadly. So I will broadly say that all of you need a will. Everyone should consider getting a will. Nowadays, I get the question, can I utilize ChatGPT AI to draft a will? I am of the position that you sure can. I know that's going to drive English teachers nuts because they hate AI, but as an attorney, I would say go ahead and use it, but take whatever is created into an attorney, have them review it, make sure they understand it. That is my caveat. It potentially, I've seen some ChatGPT wills that are very, very good, and I've seen some that are absolutely terrible. And it seems like there's no real in between. And so everyone generally should have a will. Now, what does a will do for you? Well, in essence, a will passes your assets through a probate process. If your assets are not already designated through another process, and we'll talk about that. In terms of TFFR, what we talk about a lot, and I heard Jamie talk about it a little, I did make it toward the end of her presentation, is if you don't have a beneficiary designation. Now, I asked this question at the last presentation, what happens if you don't have a beneficiary designation? And the answer was, well, you have to have a beneficiary designation. However, there is a hypothetical that could occur, as I understand it, that in terms of TFFR, that if you don't have a beneficiary designation, or you have your beneficiary designation, but your beneficiary designation predeceases you. And so let's say you're married, you designate your spouse predeceases you. Well, so what happens to any remaining benefit? That hypothetically is passed through probate. So the first lesson from a TFFR perspective is, as I understand it, TFFR does not, monitor when your spouse passes away or when you pass away. That, it takes some information to get to TFFR for that. So make sure you're informing. The first lesson is, if in the unfortunate event your spouse predeceases you, make sure you inform TFFR that your spouse has passed away and you get a new beneficiary designation in there. Or your remainder beneficiary could wind up being your estate, and then for many of us folks would go to our children, but then it goes through the probate process, which, like I say, I'll talk about in a minute. That's what you actually want to avoid. So make sure you're getting that beneficiary designation into TFFR in the event that is required. Okay, so probate process. If there's no will, the law will automatically pass any assets that you have through intestacy. And again, I guess I'm going to try to go quick, and sometimes when I go quick, I turn myself around a little bit. So forgive me because I know we're running a little bit behind. I'm starting with the probate process because this is actually the number one question. People want to understand the probate process. So that's why I'm starting here. We'll get back into more basics of estate planning in a second. But if you don't have a will, assets pass through intestacy. That's fairly simple if you are married and or have children. It becomes quite a bit more complex if you are not married and don't have any children. So it's very, very important for those folks. If you want your wishes followed, you really need a will. But even for those folks who do have a spouse and children, you really want that will so that your wishes are really followed. Otherwise, if you have a will, it's pretty straightforward. The will is going to go in compliance with North Dakota law. The assets are passed pursuant to the will. All right. So probate without a will generally is going to go to the spouse and then to the kids. If no spouse or kids, then to your parents. If no parents, then to your siblings. If none of those, like I say, it gets really complicated. I think most of us, you understand that you want that will, you want your wishes followed. What needs to get filed with the court? There's a fair few documents that need to get filed with the court. Generally speaking, you're going to hire an attorney or your personal representative, excuse me. You will be gone, so you will not be hiring the attorney. But your personal representative or the person who is supposed to be the personal representative will file this paperwork with the court. Okay. Most attorneys, to Ms. Neubauer's question, most attorneys will do a pretty simple will for you, and they're not very expensive. I generally note, we'll talk about healthcare directives and powers of attorney here in a minute as well. Most wills and power of attorneys can all be drafted at the same time. Most attorneys, they're between $500 and $1,000. It's well worth your time, because if you don't have that paperwork in place and you need a guardian instead of a healthcare directive or a power of attorney, or you need your kids or your spouse is stuck going through a probate where there is no will, that can get very, very expensive. Not unusual, $5, $10, $15, $20,000, especially if it's contested. It can get very complicated, and so it's worth, view it as an investment to meet with an attorney and go through an overall estate plan. That can be very, very helpful. Probate with a will, as I say, it'll be generate. As I say, the assets will be distributed as set out in your will, and there's something called a codicil to a will. So if you want to leave that, your grandmother's ring or grandpa's shotgun to a specific child or niece or nephew, that can be specifically done in your will. Whereas if you do not have a will, obviously the court is just going to distribute that, and in some cases just sell it to the highest bidder, so to speak. Basically need the same thing. Obviously, the biggest difference is that will is going to get filed with the court as well. Okay, so a couple of quick examples. Single person, no wife or kids. And we'll talk about Dave Ramsey. I mentioned Dave Ramsey in a second when I get into your TFFR. I don't mind Dave Ramsey, but go ahead and go through Mama Bear, or like I say, through ChatGPT, but have an attorney review it. We've seen some really bad online forms, and you don't want your will thrown out, because that ends up getting even more complicated if you have a bad will that gets thrown out for your heirs. If you have no will, if you're a single person, no wife or kids, no siblings, no parents, your estate is going to wind up going through a distant relative, and it must go through court. If you have a will, it will likely still go through court depending on your assets, but the case becomes usually pretty straightforward in terms of how you set everything out. Under North Dakota law, virtually no matter what, your taxes are going to get paid, any outstanding taxes, as well as any funeral expenses we're going to get paid through your estate before anything is distributed. Okay. So this is the next couple slides are the slides that I'm going to pause on the most. Now, generally speaking, most attorneys, and you can go to many attorneys, and opinions can vary, but for the vast majority of us these days, we are going to advise that, despite the fact that I'm advising that you get a will, that you work with your investment planner, your TFFR person, to try to do what's called probate avoidance. And probate avoidance is primarily through creating a situation where your assets pass directly to what wind up being heirs, but your beneficiary designations in your various investments. You can even do this with your homes. You can do this with your even with your bank accounts. Okay, so what we look at doing, what I look at doing as a practical consideration is as you reach toward retirement age, depending on your age, depending on your assets, we look at doing various things with your assets. So for instance, the question was asked last time at the last presentation, well, can I just put, my car in my spouse's name? Yes, you can do that. You can put your car, for instance, through the Department of Motor Vehicles. I'll pick on my family. My wife's name is Tanya. I can put it in as Thomas or Tanya Jackson. If you have your vehicle in your name only, or alternatively, you have it in your and your spouse's name, when it comes time to transfer that title, you are going to have to probate and sometimes even register that vehicle. You are going to have to probate the estate to transfer title to that vehicle, which becomes a huge pain in the butt, frankly. The same is true with your home. There are various mechanisms you can use. And if you see on this slide, the last one I talk about is a quitclaim deed. A quitclaim deed is a very cheap and easy way to transfer your home in order so that you, that when you reach that age, that you can transfer a home, your home, into the name of your spouse during their lifetime, and then leave the remainder beneficiary to, for instance, your children. Those become situations where you don't need to probate the estate any longer, right? So the same is true of bank accounts as far as checking accounts, savings accounts, so on and so forth. You can do something called payable on death. And so that asset, once you pass on, goes directly to whoever you designated as the payable on death person, so that it does not go through probate. Okay, so it is not passed by the will. It is not passed through that court process. All right, and if everything is done correctly, in many circumstances, and I'm young enough that I haven't had this happen to too many of my clients, but in some circumstances, there is no expensive probate. You don't have to worry about that. Your heirs are not having to pay for an attorney, court costs, court fees. Everything just goes directly from, my client to the person they have designated as a beneficiary, as a payable on death, so on and so forth. So again, kind of foreshadowed, but in terms of how this impacts your TFFR, it's just very, very, I cannot emphasize enough how important it is that you designate that beneficiary, make sure that beneficiary, if they predecease you, that you fix that, so to speak, and designate. As I understand it, your TFFR, you can have a secondary beneficiary on. So that's great. You should do that. But if you don't do that and you only have one beneficiary because you say, I'm not worried about it, my wife is going to live much longer than me, my husband's going to live much longer than me, great. But if they predecease you, TFFR isn't going to reach out to you. You're going to have to reach out to them. And if you forget that, that's why you have your secondary beneficiary still in place. Okay. Hopefully that makes sense to everybody. I'll talk about trusts here a little bit more in a second, but as I understand it, you can designate, if you so decide, a trust to be the beneficiary of your TFFR, if you so wish. For the vast majority of you, talking about Dave Ramsey, Dave Ramsey came out with a study that showed that teachers were the third most likely to be millionaires. The reality is that for most of you, your two greatest assets are going to be your home, but then is this TFFR plan that you have. So you really need to work diligently to ensure that your TFFR plan is, which again, for many of you is likely you're going to be your biggest asset. Work with, I think it was Miss Weeks at the last one, Miss Mutter, whoever is up at the TFFR group, so that you're maximizing the retirement that you have earned for some of you over the last 30, 40, 50 years. Okay. Can't emphasize that enough, and not just for you, but for your beneficiaries, right? And some of you, that might mean, as I understand it, you can take the single payment and things like that, or you may want to consider that, because that may provide more of a benefit for you and more of an inheritance, if you will, to your children, as opposed to the monthly payment. Though I understand from the statistics, the vast majority of you are going to choose that monthly payment. Do understand that this crosses over into what I understand is the next presenter is going to talk about. If you're getting that, trying to remember your 5 highest years of salary, and you're getting that monthly payment plus that multiple. This information also about ensuring that you have the correct beneficiary designation, that also applies, this concept also applies if you reinvest into a different retirement plan or into your insurance or whatever the case might be, okay? So it's really, really important that you work with an attorney, an investment planner, and anyone else to ensure that this asset, any of these assets, financial planner, are going through, don't have to go through probate to the greatest extent possible. Can't emphasize enough, while I am advising everybody that you need that will, yes, get into an attorney. It's worth it to get that will even looked at. If you use Mama Bear, if you use ChatGPT, nevertheless, you still need to get into that attorney. You still need to get into that financial planner to make sure everything you're doing is correct. There are other things that most of us don't think of, but I often talk to many of my clients because so many of us are living so much longer. If you live into your 90s and your kids are in their 70s and you suddenly you pass on, they might look at you when they inherit those assets at 70 and go, "It's great, Mom and Dad. Thank you, Mom or Dad. Thank you, but I'm now 70 and I just don't have the ability to do the things that I wanted to do when I was, in my 50s and my 60s." So I also encourage most folks to at least consider lifetime gifting, and I'll talk a little bit more about those minimum and maximums. I ran out of time last time because the person before me went fast or went slow, and I'm running out of time this time as well. So I'm gonna skip ahead a little bit here and talk real quick about powers of attorney and healthcare directives. I've already mentioned these. What are they? So a will is the document that impacts you once you pass away. Okay. You also need a power of attorney and a healthcare directive. These documents govern if you are unable to make decisions for yourself, and you need somebody to do anything from pay your bank accounts, make payments from your bank accounts, because you're unable to do that. Most people think of that in terms of dementia, Alzheimer's, that type of thing. But I've had those powers of attorney become effective because, frankly, my clients were down in Florida. They couldn't act, and so the pipes froze in their house. So the son used the power of attorney to do everything from hire a locksmith to get into the house, to hire a plumber, to fix the frozen pipes, and then he just used it to pay checks from Mom and Dad's account. And Mom and Dad just didn't want to deal with it, and he said, "Okay, but I'm obviously not paying for it." So those are when those can be used. Of course, they can be used at many other times. Healthcare directive is basically the same thing, except that governs your medical decisions for you. Again, most folks think about this in terms of Alzheimer's or dementia, but frankly, the vast majority of time I have seen it used is for a tooth extraction. I have gotten many calls over my career. Can you please send my healthcare directive or Joe's healthcare directive over to the dentist? He is having a wisdom tooth pulled, and they want to pull another one, and I have to give him permission to do so. So they need that healthcare directive. So it's not just for those sometimes unique situations for folks in their 80s or 90s. It can be folks in their 40s or 50s. I didn't mention this, but if I did, I'm going fast and I apologize. I get asked many times, when do I need these? You need them as soon as you have kids, as soon as you're married. If and especially if you're not married and you have medical things going on and you're over 18. That's when you need a will and a power of attorney and a healthcare directive. So basically, everyone should have one of these. If you don't already, again, yes, you can get forms online. I'm not going to deny that, but especially in the terms of a healthcare directive, there are some very specific requirements in North Dakota law that the online forms don't always catch, that you really need to go in and at least have an attorney look it over and make sure it's compliant with North Dakota law. I looked over some healthcare directives the other day, and they even said in there, they had pulled them offline, and it even said something like, this healthcare directive is in accordance with the laws of the state of Missouri or Mississippi or something. And I was like, well, clearly this is not valid. So yes, online forms exist, but it's always still worth your time to have an attorney take a look at it. Okay, I want to talk about trusts real briefly. I spent a lot of time last time talking about trust, and I think that's mostly because I got down into the rabbit hole of, for those of you who aren't paying attention, land, real estate in North Dakota, ag land, as well as your homes, they're increasing significantly in value. If you come from a family that has agricultural land, run, don't walk into the nearest attorney, and you need to talk with them about what to do with your land. 25 years ago, you could buy decent land in North Dakota, ag land in North Dakota for $200 an acre. That same land is going for $5,000 an acre. At least in Western North Dakota, if some of you are logging in from Fargo or whatever, you're going to just think that is old hat, and you're not gonna think that that's a big deal. If you're from Western North Dakota, Belfield, South Hart, Beach, wherever, you're going to be shocked when you hear me say that. But land has increased so significantly that a trust going, when I talk about quitclaim deeds generally for the last 25 years in North Dakota would cost $100, $150 for an attorney to do that. A very easy way to set a client up for a non-probate transfer that transfers very, very easily. Unfortunately, because of how land has increased in value, that sets up some tax consequences in terms of what happens with the step up in basis. That is not always great. The same thing is happening with agricultural land. I was telling the story, I had one set of land. It was a slough north of Jamestown. And some hunters came in and bought it at $6,000 an acre. It wasn't even farmable. It wasn't even tillable. It could hold 10 cows, and yet somebody came in and bought it at $6,000 an acre because they wanted to hunt ducks. The same thing is happening all across Western North Dakota, and so just really be aware of that. Trusts, for most of you, as I say, as it relates to TFFR, understand that if you have other assets that you wish to put in a trust, I personally, at least at this time, from what I understand of TFFR, I would not put a TFFR and that be the only asset in a trust. You could certainly think about doing that, but if you have other assets, you're inheriting some land, some farmland, rental property, or maybe you just started some rental properties, you can, and those are in a trust. You could certainly choose to designate as your beneficiary the trust that you have created. Generally speaking, the single tax for individuals, North Dakota has no estate tax. I should note that real quick. So in a lot of other states, if you want to move to Minnesota, for instance, when you retire and you didn't do any tax planning for your retirement, some folks are going to think that you're crazy because Minnesota does have an estate or an inheritance tax. North Dakota does not. So the next time you hear somebody say our taxes are too high, just remember this: whatever you earn, North Dakota does not have an inheritance tax. There are some federal estate tax numbers: $13.99 million for an individual, 27.98 million for a married couple. Again, I understand this seems very high, but again, if you come from a farm family and you start to run what mom or dad are running, if they're running a couple sections, it doesn't take very long before suddenly you're hitting those estate tax issues from a federal perspective. I note just real briefly that all trustees, they owe a fiduciary duty and an obligation to the beneficiaries. Just note that. So if you're concerned about leaving something in a trust and a bank being the trustee, or your brother Bill being the trustee because you have younger kids, and that's who you designate as the beneficiary of your TFFR account is your trust that you set up, they being the trustee will always have that fiduciary obligation to act in the best interest of the beneficiaries. That is to spend the money and invest the money for the benefit of, in this example we're giving, for your children. Okay. There's two types of trusts. Again, I'm going pretty quick, but there's the first is generally an irrevocable trust or an irrevocable trust. I won't talk about that too much here today, but basically it's a trust that can only be modified by the court. These are used sometimes quite sparingly. They were in vogue to use a lot at one point, but they're now used quite sparingly, except in certain cases. Revocable trusts can be revoked or modified by the settlor. That is the person who created the trust. In this case, for purposes of this presentation, that would be any one of you. Basically, a trust is created through a written instrument. It can be created through a will. Oftentimes, this is called a testamentary trust. So, for instance, going back to using a mama bear form, if you have children and you're trying to use that mama bear form, you really got to be, none of the forms I've ever seen create a testamentary trust for minor children. And that is not, so that's not going to satisfy what most of you probably want to do to protect your assets for your kids through your will. Okay. So for most of you, maybe all of you, most attorneys are going to recommend that if you have minor children and you are drafting a will, you create a testamentary trust, and then that, when you designate your secondary beneficiary on your TFFR account, right? Your primary beneficiary, if you're married, is going to be your spouse. We'll use a kind of a stereotypical nuclear family, I think is what it used to be called, right? Husband, wife, kids. Most of you, your primary beneficiary designation is going to be your spouse, and then your secondary beneficiary may be the John Doe testamentary trust, so that the TFFR account can be utilized by your children. Your standard online form is not going to know the nuances of doing a testamentary trust, at least not yet, to create that for your kids and to protect that for your kids. Okay. Again, I mentioned trusts. The benefit of trust, which you don't want to do in a will, is that many trusts can provide for certain conditions that have to be satisfied. Keep the land in the family. Make sure the land goes to John and Bill, so long as John and Bill are farming. I've seen a trust that didn't go to any of the beneficiaries until one of the beneficiaries maintained sobriety for 5 years. They can be used for a variety of things. These are generally things that you cannot do through a will. So subgroups of trusts, just so everyone is aware, we talked a little bit about a testamentary trust that is typically through the will, and then can also have other things within that will, within that testamentary trust that also includes different things here. We can have a special needs trust. This is a trust for a disabled child, sibling, what's called a spendthrift trust, which does not keeps. Maybe you have your brother-in-law likes to spend money, likes to go down to the casino. You can create a trust where creditors can't come after your sister then because your brother-in-law is going down to the casino too much. I don't know why I'm picking on brother-in-laws now. Charitable trusts. Most folks don't need a charitable trust, but if you are in that position that you are thinking of them, I'm Catholic, so I am aware that that one of the online charitable trusts that you can find is through the Catholic Church, through the diocese. One of the few trusts is a Medicaid or nursing home trust. I'll talk about Medicaid here and nursing home eligibility here more in a minute. And I've only got 5 minutes left, so I'm going to go through this pretty quick. As I think Jamie kind of said, this is kind of high level, and we're pretty limited on time. So this is kind of mentioning everything in about 25 minutes, a half an hour. But it is why I start off by saying you should go to an attorney. Virtually all of you should have wills already. Virtually all of you should have healthcare directives already. If you're here thinking about retirement, you also need to be thinking about estate planning. It is really that simple. And lest I seem like I'm shilling just for myself, I tell folks, don't just come to me. There are plenty of attorneys who do estate planning throughout the state. Go into somebody. You really need to be comfortable with your attorney, whoever it is, just like your investment planner, your doctor, your lawyer. You need to be familiar with those folks and be comfortable with those folks. So one of the few trusts that we can talk about is for nursing home planning. And again, nursing home planning is no different than tax planning, in my opinion. And in fact, the North Dakota Supreme Court has said that attorneys who do estate planning, we need to at least mention Medicaid or nursing home planning to folks. Okay, so what this is that if you do wind up in a nursing home, or if you have mom or dad or brother or sister, this applies to you as well, who may wind up in a nursing home. There are certain steps you can take to protect some or all of your assets from being paid for by the nursing home. And one of those is through an irrevocable, non-assignable, non-transferable trust. And so that, again, going back to the rapid increase in agricultural land and even in home prices, you may wish to put your home or put that agricultural land in a trust, in certain kinds of trust, so that we're not selling land in order to pay for Medicaid. I know some folks get a little concerned when I say that. It doesn't seem like it's right, but like I say, it's no different from tax planning. If you go in and you meet with an accountant to try to minimize your tax consequences, that's no different than trying to minimize your liability for Medicaid purposes, i.e. what you spend on the nursing home. All of us have been paying into Medicaid, Medicare, taxes for years. You don't want to put yourself in a situation where you simply don't get to use it. So, assuming basically, and I got 5 minutes left, so I'm going to go through this really, really quickly. Basically, no matter if you go into a nursing home or you have to apply for Medicaid, you're always going to have something called recipient liability. What that recipient liability generally consists of Social Security, any annuity, any trust income, any investment income. Okay, so again, in terms of TFFR, how does this impact me? Well, I take you, not me. You decide to take that monthly payment. You wind up in a nursing home. That your monthly payment is going to go toward your recipient liability every single month. Every single month, that's what's going to happen. And so you need to be aware of that in terms of as you start to get your payments from your retirement account, you may wish to put those payments somewhere else to protect them, so that recipient liability doesn't go straight to the nursing home in the event that ever happens. I think I heard Jamie and Sarah mention that they had somebody drawing on their account for 50 years. That's fantastic, but if you're spending the last 20 of those years in a nursing home, they're drawing on it, that's great, but it's all going to the nursing home. And so that's not accomplishing, for my guess is for the vast majority of you, that is not accomplishing what you originally wanted to do when you got this great benefit. Again, for most of you, this largest benefit, this TFFR account. So again, the biggest thing to walk away from this presentation today between those of us who are presenting is meet with your TFFR person to see, and your attorney and your accountant and your investment planner, to see what you can do to try to help help yourself. So not all of that is going into just straight into the nursing home when that day comes. Okay. I know I'm just about out of time. I'm going to skip the examples. I mentioned quitclaim deeds. Again, these were used by virtually every attorney to do that, what's called probate avoidance. It's a transfer of real property and then gives what's called a remainder interest to whomever that might be. I use the term heirs in this. Heirs is not really the right phrasing because you can leave it to anybody. You can leave it to folks who are not your heirs. But I do mention here that the Medicaid look back is 5 years. I also mentioned that lately we used to do this almost always in the early aughts and into the 20 teens, but it's from a certain perspective falling upon disfavor, in my opinion, because increasingly I'm running into it that house that somebody bought in 1995 for $100,000. They've made some improvements. They've replaced the carpets. They've painted. They've got new siding. Whatever. And now in 2026, that home is selling for $450,000. If they quitclaimed it in 2016, that's when you get the step up in basis, or that's when everyone gets the step up in basis. So there's then tax consequences in terms of what's happened between 2016 and 2026, which are causing a few problems in terms of how that is valued. I know I was supposed to be done at 11, Sarah. You gave me a little extra time. I've been whipping through this on purpose, but I would deem myself more or less done, except for this slide. Plan of action. One of the things I talk to people about is, like I say, if you're here thinking about retirement, at some point you really need to talk to your kids, your spouse, your siblings, whomever are your heirs, whomever you intend to leave your estate to. Now, if you're in your 40s and don't have any medical condition, and you're just really wanted to know how great this TFFR is, and that's why you're here today, okay, you don't need to worry about this probably too much. But if you're in your 60s and your kids are in their 30s, I would advise you need to really sit down with your kids and your spouse and talk about the best way to do this as you reach retirement age. And the same is true if you're in your 50s. At least your spouse, and you're getting to the point where you really need to start thinking about these things. You see that second yellow slide there, and you're probably wondering what I mean by that. But what I usually encourage folks to do is, when I meet with people, that's the question I ask. Where do you see yourself in 5 or 10 years? And this is true now back if you're 30, if you're 40, if you're 50, if you're 60. Obviously different things for different people. If you're 60 and you're looking at you're going to be vested in 2 years, and once you start drawing on your TFFR or your other investments and you want to travel, that's a very different thing than somebody who's in their 30s who's just saying, okay, when I draft, or I'll use it differently, somebody who's in their 50s and they're saying, okay, I need an estate plan to provide for my spouse and my kids, Tom, versus the person in their 60s who are saying, I want to make sure that I have an estate plan that allows me money, financial freedom to travel, and so on and so forth. As I started by saying, I will end by saying, I understand that there's a lot of online forums that make things simple these days, and they're not necessarily bad. But that said, you must have an attorney review them. There is nothing worse than, and I have probated a few of these forms from the various, I don't know where they come from, online somewhere. Some of them are fine. Some of them are really, really bad. If you have a really, really bad one, that actually makes things worse. So it's worth the time, it's worth the money to sit down and at least have an attorney look at it and say, okay, this is a good start, but these are the changes we need to make.